Hello friends, welcome to our channel Legal Nexus. Today we are going to discuss about state liability for tort. This principle originated from England. In England, the king can do no wrong was a maxim prevailed for centuries together. Above mentioned maxim was based on the principle that no human agency could enforce law against the king as he was the ruler and all the court were his court. He could sue others, whereas others could not sue him. In the 20th century, the system of monarchy became absolute and the Crown Proceeding Act 1947 passed to place the ruler also in the same position of an ordinary citizen. This act had necessarily to pass due to the expanding commercial and other ancillary activities of the government, of which the Crown was the head. Before 1947, in England as well as in India, the king could not be sued for torts in his own court under the doctrine of sovereign immunity. The Federal Tort Claims Act 1947 and the Crown Proceeding Act 1947 entitled the affected victims of the Tortious Act to recover damages from the Crown. Article 300 of the Constitution provides that the state or government may sue or to be sued for the torts as in same manner before the enactment of the Constitution. Respondent superior meaning let the principal be liable and cuficit peralem per se, which means he who does an act through another does it himself. To identify the state liability to tort, we have to come across the functions of state. Functions of the state can be divided into two, sovereign function and non-sovereign function. Sovereign function means these are the functions that can be only carried by the government, not by the private individuals. The government runs these departments mainly on basis of service motive. These are no profit earning principle. Evading the exercise of sovereign function. The government is not liable for any tortious act committed by its servants. Non-sovereign function. These are the functions that can be carried out even by the private individuals. It is run with profit motive and hence compensation is always given. The following are the important case laws to distinguish between sovereign and non-sovereign function. P&O Steam Navigation Company versus Secretary of the State. The servants of a dockyard were carrying iron rod and were crossing a road. When they were at the center of the road, a horse with a coach rushed towards them at the high speed. The servant dropped the iron rod and ran away. The horse fell down and subsequently died. The Supreme Court held that the Secretary of the State was liable for negligence of his servant in the same way as the ordinary employer is liable as it was non-sovereign function. Vidyavati versus State of Rajasthan. A government jeep driver driving a government jeep after repairs from a workshop knocked down a pedestrian by his rash and negligent driving. The pedestrian sustained injury and subsequently died. The widow sued for damages. The Supreme Court held that driving a jeep from the workshop was non-sovereign function and hence the government was liable to pay damages. Kasturilal versus State of UP. Kasturilal was arrested under suspicion that he was keeping stolen jewels. The jewels were taken from him and kept in police custody, but after verification, it was found that he was a bona fide person and hence released. When the jewels were to be returned, they were found missing. A police constable stole them and ran away to Pakistan. In an action by the affected party, the Supreme Court held that it was a sovereign